Guys, I have to say, this the mind is focused on this DACA stuff. Are we doing this follow-ups thing? I still think we should do follow-ups at the end. I don't know why we do them at the beginning, but...
That was very focused, Ruchit. Is DACA a follow-up?
No, isn't DACA the main point of what we're talking about today? I thought we were talking about DACA and these last couple of these cases, including one that came out, I think about a week ago from federal district court in Brooklyn.
All right, let's do follow-up first. So the reason why we do follow-up first is that's just how every other show does it, including John Siracusa, copyright 2011, John Siracusa, trademark. John Siracusa, the greatest living podcaster. He invented follow-up. Well, can I give a little aside about our history with immigration and DACA?
Please.
We did a show on episode 36 called Everything We Know About ICE, where we discussed immigration and probably DACA, but I can't tell for certain. And the reason I can't tell for certain is because this show was an episode where the three of us had decided that AJ and I were really busy, and Ruchit was not as busy, so Ruchit was going to do the show notes, but he did not.
Wow. Tom, you had to use this moment, of our unity as a country to tear us apart. What are you, the president of the United States?
Yeah,
What's going on?
Ruchit promised to listen to the show, just one episode, and he promised to do the show notes, but he didn't. So we have no idea whether in that episode we talked about DACA or not.
But don't we have a show called Everything We Know About DACA?
I'm like 80% sure we do. Well, we have a list of shows.
I'm going through the list. We've talked about common carriers.
North Korea, Parliament, Jeff Sessions, BCRA.
We have a picture of me with a tub of popcorn.
Don Jr., Supreme Court.
Equifax.
Coffee.
North Korea. David Brooks. We've even talked about David Brooks. We've talked about Sheriff Joe. I don't remember talking about Sheriff Joe.
We had an entire episode about Sheriff Joe.
When was this? Apparently it was September 2nd, 2007 when this episode
Coffee
was posted.
Saudi Arabia.
Why did we talk
Jim
about
Comey.
Sheriff Joe?
Maybe don't forget Neil Gorsuch, our very first episode. Bitcoin, I regret that episode. Impeachment.
Parliament.
Macron, I regret Macron. Trump care. Death penalty.
BICRA. I regret
Simon
all of
Tam,
the BICRA
voting
episodes.
rights. FCC.
The BICRA episodes were real.
The Freedom Caucus. Textualism. Oh my God.
Don Jr. Why did we talk so much about Don Jr.?
Racism. Guns. Border searches.
Saudi Arabia. That was a good episode.
Okay.
I remember that episode. Gosh, now I'm starting to understand why people binge listen to our show. We've covered, if you just did nothing but listen to our show, like all 40 some odd episodes, you would know a lot of stuff.
This morning, NPR had a story about these two sisters who were dreamers, but only one was covered by DACA. I'll put this link in the show notes. Basically, what happened was one of the sisters was not 15 at the time DACA was initially, implemented by the Obama administration. And then when she turned 15, she was in high school and wasn't really looking for work. So she didn't really, as any 15-year-old might do, put off things like this. And then Trump was elected. And so she went to her lawyer saying, hey, maybe I should do this. And her lawyer's like, you probably shouldn't give your information to the Trump, ICE. And so it creates this awkward thing where one sister who did do the DACA provisions and actually sued to keep the renewals going and won her lawsuit and is being appealed all the way up probably to the Supreme Court. And this other sister, or her sister, who didn't apply and is living in fear.
Wow. The okay, couple of housekeeping questions, which should appear on the show. So I don't listen to our show. I don't really have time to listen to our show. Have we? And I don't remember most of what we've covered on the show. So, question: have we ever talked about DACA on the show?
This is a good start.
All right. So I don't know if I've mentioned this already, but to our listeners that binge listen us, and you might be thinking, Ruchit, you said this exact same thing on episode 33 or whatever episode it was. I apologize to you, but this entire thing is not only very heartbreaking, but people that are opposed to DACA, I'm strained to say this, but I think they are heartless or do not understand what DACA is or do not understand what, I guess, just the sheer amount of pain people are going through. And just when you think human to human, should another human go through this much stress and pain for absolutely no reason whatsoever? It seems to me not. I mean, so we've explained what DACA is. Our listeners should know what DACA is, I assume.
All right. I have a hard stop. I have a hard stop at 9 o'clock. So let's do this. Let's do the cases.
I have a hard stop at 8:30. Let's do it. Let's go.
Wait, really?
Yeah.
Oh. Well, then we really need to get started. Okay. So in September of 2017, Donald Trump announced his intention to rescind DACA. DACA is a program whereby people who arrived in the United States as children, even if that entry may not strictly have been authorized, are allowed to remain in the United States. They get authorizations to work in the United States. It's a good program. We are lucky to have it. Is that a fair synopsis?
It's a humane program. Yeah. Can we just say one other thing? I'm going to say one other thing. It's a humane program because if you came to this country without the proper paperwork and your parents brought you here and this is the only country you've ever known and you've been a good citizen in this country, you don't have a criminal record, you've been here for a long time and you should be allowed to stay here. Like, it's not your fault that you were brought here when you were 3 or 4 or whatever the age may be as a child. And the idea to punish you for what your parents did, whether or not one believes that initially was wrong, but to punish you for what your parents did is a fundamentally, I think, un-American idea and unjust idea. So that's why this idea to protect this class of people from ICE and from deportation is, in my view, a very good piece of public policy.
So let me ask you, can I ask you a question?
Yeah,
what do
of
you
course.
think, how do you respond to conservatives who just call it,
Wait,
are
guys,
opposed to the,
hold on. Pause
the
for a
DREAM
second.
Act?
Guys, we have like 2 very specific court cases to get through.
Yeah, no, but
Yeah,
Tom
it'll
is
be
saying
okay.
something
Okay.
good. It'll be
Yeah,
okay.
it'll
We'll get
be
through
okay.
it. Don't worry.
Okay.
Don't worry about it.
Yeah. Yeah.
So my question is, what do you say to conservatives who, are opposed to the DREAM Act because they think it's illegal immigration, that it's.
So here's what I would say, is that we have to stop getting caught up over this idea of, well, they broke the law. You break the law every day. I probably, but would never admit, also break the law every day. In the sense that I jaywalk, you jaywalk. We all do certain little things that are technical violations of the law. The purpose of the law is not merely to state what is legal and illegal. It is to reflect what is just and what is unjust. So you need to start not with the premise of what is legal and what is legal, but you need to start with like what would justice actually look like? Because the law isn't some sort of fixed thing that cannot be changed. So I think that's the first thing that anybody that thinks of this, well, it's illegal immigration, full stop.
Yeah.
Needs to recognize that to begin with.
In all fairness, you can say there's a difference between jaywalking and immigrating
You
legally,
could.
or
You could.
There's a difference in degree, right? And I'm sure that's what they would tell you.
Yeah, and so what I would say in response to that is you have to look at the specific situation as it relates to this specific class of immigrants. And these are people that were brought here as children. The vast majority of them know no other country than the United States. So is it just to deport them to a country that they probably don't even remember, a language that they don't even speak? And what harm is it doing to allow them to remain here, right? In virtually all cases, these are people that are, serving the country by paying their taxes and are just living their lives. There's no reason to believe that they're dangerous. And in any situation, I think I think everybody would be amenable to background checks and all of these other things that, if you said, listen, this is a condition of this person being able to stay here.
Well, at the end of the day, the Obama administration imagined DACA to be a matter of prioritizing certain individuals for deportation versus other individuals. And so, from the conservative viewpoint, in terms of we have, but not just limited government, but we have limited resources, right?
Yes.
So a limited government with limited resources, the question is how best to use those resources. Is deporting individuals like this the best use of our limited resources?
Does anyone want to talk about the cases?
What cases?
Oh my God!
Let's talk about the cases, AJ. Okay, let's do it, dude. I'm ready to talk about these cases.
Okay, let's start from the top. DACA, right? We talked about that. So in September of 2017, the Trump administration said they would be rescinding the DACA program. What they said was that they would be sunsetting it through March, and that they wouldn't be processing any renewals after March. They wouldn't be accepting any new people into program effective immediately, and then starting in March, the program would be sunsetted and folks would start getting deported. So March is upon us, and 2 different federal judges have enjoined that course of action. What that means is that the government is prevented from ending the DACA program. So what is interesting, so these are preliminary injunctions. These aren't sort of like final court decisions, and that means that the case isn't over. But during the time that these cases are ongoing, the government has to follow this injunction. So the 2 cases are Vidal v. Nielsen.
Great case name.
And that is in the Eastern District of New York. And then the other one is Regents versus the Department of Homeland Security. And that is in the Northern District of California. And so both of these judges in 2 different jurisdictions had like fairly similar reasons for saying that the government had to continue the DACA program. And I think this is super interesting. The reason why doesn't have to do with any sort of like due process rights for DACA recipients. The actual rationale here is that the government did not use a reasoned deliberative process in choosing to end the DACA program. I think that's an extremely interesting rationale for enjoining the federal government's policy.
So can you explain that a little more?
So in order to talk about DACA, you actually kind of need to talk about DAPA first. So DAPA was a program that the Obama administration started after DACA. And so DAPA applies to the parents of U.S. citizens. And so if you are in the country without authorization, but you have children that are United States citizens, then DAPA is sort of a similar exercise of discretion to the DACA program, but it applies to these parents. Now, about 27 states sued, including Texas, and the case is referred to as Texas. Like that'll be what we'll call that case, and that went up to the Fifth Circuit. And so in the Texas case, the Fifth Circuit said that DAPA couldn't go into effect, that the government sort of couldn't codify and give work authorizations to parents of U.S. citizens using the DAPA framework. And the reason why is 2 reasons. First, the lower court said that DAPA didn't follow the Administrative Procedure Act. And so the Administrative Procedure Act says that there's a certain process you have to take for enacting government policy, and the Obama administration didn't follow the right procedures in adopting DAPA. But the second thing they said is that DAPA conflicts with the INA, the Immigration and Naturalization Act. And so the court in striking down the DAPA program specifically said that they weren't striking down the DACA program. And the 27 states led by Texas, didn't sue against the DACA program. I think they realized that the DACA program is much more politically sensitive. It would have been sort of much less politically savvy to sue to enjoin the DACA program. So where we're at now is that the rationale that the federal government gave for rescinding the DACA program is that Jeff Sessions, the Attorney General, issued an opinion saying he thinks that the DACA program has the same statutory and constitutional infirmities that the DAPA program has. And what both of these judges have said is that conclusion, that the rationale that the Fifth Circuit used in striking down DAPA could apply to DACA, that rationale is a mistake of law. It is erroneous, and it is in fact it's a clear enough mistake of law that the government's policy was not adopted in a manner that has the sort of reasoned decision-making process that you need in order to have a valid government program.
This is really interesting to me because, first of all, it's like pretty clever lawyering, right?
Right.
Which is like always impressive to me, I guess, as a lawyer. The second is that, do you guys know of any other time where an administrative agency has used as its justification for enacting or rescinding a rule or policy that some court might find it unconstitutional? So that's the first thing. And then I guess the second question is related. Do you know of a court ever sort of saying that your legal conclusions are erroneous? Do you know what I mean?
Yeah, so I can give some background on that. Under the Administrative Procedure Act, the government has to follow certain procedures when it adopts certain policies, and the procedure is called notice and comment. And so the government has to give notice of the planned course of action. It has to give parties an opportunity to comment on the planned course of action. And then in adopting whatever policy the government ends up adopting, they have to give a reason, they have to give a reason justification for why they adopted the policy. And the courts have held that when a policy is adopted, it is then reviewed under the arbitrary and capricious standard. So the policy, the reason justification, and the administrative record have to substantiate the idea that this is not an arbitrary and capricious course of action. And a policy is per se arbitrary and capricious if it is based on a mistake of law. So there's actually a decent body of case law that lays out sort of, when this administrative agency has made a mistake of law in pursuing the adoption of a policy under the Administrative Procedure Act. That mistake of law means per se the adoption of the policy was arbitrary and capricious, and the policy will be struck down.
Something interesting that we might want to talk about, and if it's not interesting, I guess AJ can edit it out, is why do we have this kind of quirky system like that? And why do these agencies have to jump through what I think a lot of lay people might look at as just, technical hoops? Why do they have to do this like kabuki theater dance in order to pass these regulations or to repeal these regulations? And it's interesting to me because, before going to law school, you wouldn't have thought about why do agencies even exist? Like what power do they have? Where do they, why are they a thing? Right? Because, you traditionally think, okay, Congress passes the laws and then the president signs those laws into action, and then
you have a law.
Yeah. And then the executive, faithfully executes those laws. Right. And then you go to law school and then you learn that the vast majority of laws are actually created by these agencies, these, what some people might characterize as unelected bureaucrats. And so, and it really is the vast majority of laws are created by these agencies, and they have to have, in our constitutional scheme, they have to have a source of power. They can't just, take over legislative function without, some sort of constitutional authorization. And I think how many times are agencies mentioned? Heads of departments are mentioned in the Constitution once, right?
Yeah, it's not many times.
Yeah, and so, part of the reason why courts have created or have this sort of kabuki theater dance in terms of agencies creating this law is in terms of how reviewing agency law is, well, without it, if agencies could create laws at a whim, and they'd truly be unanswerable to no one, and it would almost be like Congress is abdicating their constitutional functions.
Yeah, it might be helpful to spend just like 2 seconds, Tom, on like answering that question, which is why do agencies exist? Like, why doesn't Congress just write very specific laws that say exactly what needs to be done? Like, why are they so lazy?
Well, it'd be totally impractical. So, okay. So here's the wrinkle. Here's the thing I've been working towards this entire episode. I've been very excited for over 30 minutes now to talk about this very, very specific wrinkle, the thing that I think makes the cases so interesting. I'm very anxious to get to the wrinkle.
What's 5 more minutes?
No, we're going to do the wrinkle now. No, come on. I actually chose the topic for the episode. I actually read the cases. I did all the preparation. I get to tell you what the wrinkle is. That's the rule. If you want to choose when to talk about the wrinkle, you could pick the topic for the episode.
Okay, what's the wrinkle?
The wrinkle. Okay. Do you think that the original DACA program was adopted using the notice and comment procedure under the Administrative Procedure Act?
I don't think so.
Yeah, I don't think so either.
Wasn't that strange?
The suspense is killing me.
What do you think? Was it?
I said I don't. But what's the truth? What's the reality?
It was established by memorandum.
It was established by memorandum.
Whoa.
Tom's right. It was established by memorandum of Secretary of Homeland Security Janet Napolitano. And it was not published for notice and comment. It didn't follow the Administrative Procedure Act's rulemaking criteria. And so here we have a situation where a program was adopted without providing notice and comment, but rescinding that program requires notice and comment.
Interesting. So how did the court address that?
Yeah, exactly.
What did the court say?
Surely you're not the only one that figured that out. Although, given the lawyering at the Trump administration, maybe you are. Fuck, why did we mention this, AJ? Why are you giving them the secret? We all know they listen to the podcast religiously.
Mike Flynn does. He's got nothing better to do,
We need to do some more. We haven't done a good Russia episode recently. Or Mike, people are falling right and left. They're just getting indicted and pleading guilty right and left. And I feel like
stay on topic. Okay,
AJ, keep us on topic. So
ask the obvious question.
How can this be? How can it be that a program that you established by memorandum and not the Administrative Procedures Act, in order to change that program or withdraw that memorandum, like, can't they just delete the memorandum? Can't they just hit delete on the servers? You know what I mean? Wipe it off the cloud.
So this is actually super interesting, and in particular, Judge Alsup in the Northern District of California case has a really interesting passage in the order on the injunction. Let me pull this up. It's super interesting. It basically says that each component of the DACA program was an existing program for the federal government. So what the judge here is saying is that every component that together comprises DACA is actually something the government was already doing. What comprises DACA? Deferred action? Well, the government has been granting deferred action for like 30 or 40 years now to people. Is it granting deferred action via program as opposed to ad hoc individual grants? No. First of all, DACA is structured in a way where each grant of deferred action is actually an individualized case that the agency retains the discretion to rescind or to deny any application for any reason. So is it the work authorizations that come with deferred action? No, the government has been providing work authorizations to people who have received deferred action for years and years and years. Is it certain other relief that you get for having a deferred action status? No. The government's been granting all sorts of extra relief, dating as far back as the Bush administration, the George W. Bush administration. Is it combining all these elements into a program? And here the judge says no. If each step is within the authority of the agency, then how can combining them in one program be outside its authority, so long as the agency vets each applicant and exercises its discretion on a case-by-case basis? So basically what the judge is saying is that the actual DACA memo from Secretary Napolitano, all it did was take a bunch of stuff the agency was already doing and give it a name.
That's like saying that, I mean, I don't know. This seems like a little bit of a stretch, right? Let me play devil's advocate here. I mean, it seems a little bit like saying, hey, you know, this episode of The American Heartland isn't actually a new episode because all we're doing is really just readdressing, you know, things that were in episode 4, episode 7, episode 24, episode 33.
It's all follow-up.
It's all follow-up. Like, that's sort of the court's argument, is that, listen, this memo is all follow-up. It's almost like they were just like, hey, for convenience, you know, just so you don't have to read all these statutes, we've created a table of contents for you, you know?
Yeah. I mean, I think you're right. This to me is like really curious.
Yeah, this is a weakness for the plaintiffs here.
Yeah, isn't that like super? Isn't that like so? This is why I wanted to talk about these cases. This is why I found these cases so interesting, right? Basically, both of these judges have said that the rescinding DACA requires notice and comment, or at the very least, a reasoned justification, a non-arbitrary and non-capricious action by the agency, that relying on Jeff Sessions' clear mistake of law renders the decision to rescind DACA arbitrary and capricious. And meanwhile, the actual adoption of DACA in the first place didn't follow the APA.
That is curious and I think problematic. Why didn't they follow the APA?
Clever lawyering.
But they should have just followed the APA, like in promulgating DACA to begin with. Like, the APA kind of sucks, but it doesn't suck that much. You know?
I don't know.
Like, you just do it. Like, you just put out the guidance, you get a bunch of comments, you ignore the comments like the FCC does, you know?
So I sort of suspect
you just do what you're going to do. Like, I mean, not that hard.
Because we live in Texas and the Texas APA, like, people tend to take pretty seriously around here, I sort of suspect that we have a different view of what sort of agency actions require notice and comment compared to sort of the rest of the country. I think Texas is sort of special among the jurisdictions in its view towards administrative rulemaking, and I don't think the federal government and I don't think most other states take the APA, view the APA in the same light that we do.
The other thing that will be interesting is there's those three components, right? The first is that there's the notice, then the comment, and then, you know, a reason for your decision that is not arbitrary and capricious. So another thing that will be interesting is if Jeff Sessions interprets this law, right, and reasonable people could disagree on the interpretation of whether DACA is constitutional or unconstitutional, then, you know, does he get sort of the equivalent of like Chevron deference? Do you know what I mean? In his interpretation.
No, I mean, I think both of these judges make it very clear that the Sessions memo is really just a clear mistake of law. Like, I don't think that there's a lot of room for reasonable people to disagree about whether the Sessions memo provides an adequate administrative record to support the decision to rescind DACA under the arbitrary and capricious test. To the extent that this is a decision that should be reviewed under the arbitrary and capricious test, it clearly doesn't pass the arbitrary and capricious test. Like, that part I think the judge got right. The likening of DACA and DAPA in the way that the Sessions memo does is one, clearly erroneous, but two, the Sessions memo is like so cursory. The actual extent of the administrative record is so slim that, you know, I mean, it's possible. I mean, and both of these judges are very clear in saying that it is totally possible for the government to come up with an adequate administrative record to support rescinding DACA. They just haven't done it yet. And something else that stuck out to me is that in the Northern District of California case, the judge makes a point in the order of talking about how the federal government was playing possum with the discovery process. That you know, one of the things you do when you challenge an agency decision is you like ask them, what's the administrative record? Like what comprises the record that supports the agency decision? And what you're supposed to do is in under the in reviewing things under the arbitrary and capricious standard, you look at the actual administrative record before the agency. So something could be a perfectly good idea, right? I mean, you just as an example, the FCC could come out and say, we ban spamming people. And spamming people is bad. We all agree spamming people is bad. There's absolutely good reasons for spamming people. But someone sues and the court says, all right, turn over the administrative record. And the FCC doesn't turn anything over. They turn over one Vox.com explainer about spamming people. And that's the entire administrative record, right? That would be struck down under the APA, even though it's a perfectly good policy, right? And so the judge says, right, the administrative the review of an administrative decision can have this bizarre formalism to it that you're limited to the administrative record. Well, the federal government didn't turn over the administrative record.
Why didn't they do that?
They played possum in the discovery phase. They said that there's there's some number of tens of thousands of pages that comprise the administrative record. It's all privileged. And the only thing they turned over was a bunch of publicly available documents that the court already had access to. And the government said that comprises a sufficient administrative record for you to do whatever you need to do. So I think that is also an important thing here, right? For the government to be playing possum like that, I think doesn't put the judge in a state of mind to be supportive of the government's cause.
I think this is a very interesting set of cases too. I agree with you, AJ.
Yeah.
And I hadn't even realized that thing that you were talking about.
Yeah. So this I think is super interesting. I think this is something to keep an eye out for, in the appeals process. I mean, these are only preliminary injunctions, right? So the preliminary injunction could get stayed by a higher court. Two, the court still needs to have a trial and decide whether to have a full injunction, and then that injunction needs to get appealed. I mean, this is going to be a while in the process. Probably by the time the administrative litigation has run its course, by the time that happens, the government will have just gone and fixed whatever the defects that the judges identified here are, and gotten a better administrative record to support rescinding DACA. So I don't think this saves the dreamers. I think it does delay the rescission of DACA by several months. I mean, it means that it means that Congress doesn't actually need to pass some sort of DREAM Act by March, which was the previous deadline, right? They bought themselves an extra couple months by losing this lawsuit. So, I mean, that's good, right? I mean, there's a meaningful improvement in people's lives that will result from having gotten a good result in this litigation. But in the meantime,
yeah, in the scheme of things, it doesn't. I mean, I agree with you that it's definitely good. But yeah, it doesn't stop the freight train, right? It just slows it down.
And people are still living in uncertainty.
Yeah. So, I think these cases are super interesting. I think this is a really bizarre sort of rationale. Not bizarre in a way that is implausible, but I think, I actually think if you go and read, especially the Northern District of California opinion, that sort of explains in sort of detail why you didn't need the APA to enact DACA, but you might need the APA to repeal DACA. I think when you read that, I find it fairly persuasive. I think it's totally reasonable.
Yeah, it sounds plausible. I did read it. Yeah, it sounds it makes sense. I still quibble with the idea that this memo was just a table of contents or something, as opposed to having actual operative effect, right? And so it also, I guess, it was persuasive and it made sense what the judge was saying, but it also seemed odd to me that you could just say, hey, we've been doing 17 things forever. I mean, it's sort of 17 statements, while individually true, when strung together, could create something that's completely different than any of those 17 statements individually, right? The sum is greater than the parts kind of concept is how I suspect John Roberts will refer to this.
Well, anyway, I mean, I hope something gets figured out for the Dreamers sort of as soon as possible. Maybe that's a good place to end on this, because it's already 8:10. Ruchit's got a hard stop at 8:30.
This was good. This is a good conversation, guys. I can really see our listeners, after suffering through the last episode, say, hey, the heartland is back. You know what I mean? It's like America suffering through 30 years of stagnant wages. You know what I mean? And it's the heartland is back, baby. Kind of like that.
One other thing very quickly is that, do y'all remember when Donald Trump just announced on Twitter that he was going to exclude transgender people from the military?
I do remember that. It's a good thing he doesn't have to follow, or actually I wish he did have to follow the Administrative Procedures Act.
Okay. Well, in a case, Stone versus Trump, in November of 2017, that policy was enjoined. And the reason why I'm just mentioning that as part of this conversation is that according to this opinion, the administrative record, the sort of the reasoning that the government used behind this decision is like totally inadequate. It basically, according to like subsequent reporting and according to this opinion, the generals who were supposed to implement this were totally surprised, and this was not like a well thought out or orderly decision making process. And then the opinion itself embeds screenshots of Donald Trump's tweets.
Seriously?
And those tweets were like from a month before the actual memorandum that codified the policy. I mean, the judge sort of lays out the case pretty clearly that basically this is something Donald Trump decided one morning, announced on Twitter. And that is like, something for Donald Trump to just decide and then later announce is like not a sufficient decision-making process to support changing the government's policy. So it's just another case where something that is almost certainly within the government's authority, they just didn't do the process right. They didn't do the process right, and the court's sticking on administrative process.
I love it. All the just sort of morass of government policy making really comes off handy, where it just prevents people from, I guess I doubt the creators of the Administrative Procedures Act were worried about, presidents doing things by 40-word decrees without thinking about it at all. But, hey, it works.
So anyway, do you want to talk about this, the Pennsylvania thing?
Sure, dude. But what is there to say?
A lot. A lot's happened.
This, I hope we have listeners in Pennsylvania at this point.
So the very most recent episode, the episode immediately before this episode, we talked about League of Women Voters versus Pennsylvania, right? And what we talked about was that the Supreme Court of Pennsylvania had decided that the state constitution barred partisan gerrymanders, and that even though the federal Supreme Court wasn't planning or didn't have a standard that they had decided on yet for addressing partisan gerrymanders, the Pennsylvania Free and Fair Elections Clause in their constitution tells you what to do in the case of a gerrymander, and so they're going to go ahead and fix it. So now we have the new maps, and so 538 and a few other folks have done an analysis of the new maps that have been adopted by the Pennsylvania Supreme Court, and it basically is as good as the Democrats could have hoped for. It's actually slightly better for the Democrats than some of the Democrats' own proposals for reversing the partisan gerrymander in Pennsylvania. And so Nate Silver says that, these new maps probably only give the Democrats about 2 seats relative to the current map going into the next midterms. But one way to think about this is that the about a fifth of the seats the Democrats need to retake the House are sort of readily attainable in Pennsylvania alone.
Wow. I did not know that. Did you guys know that we have, so I just realized this, but so I'm in Roger Williams' district, the used car salesman who's famous for promoting policies that benefit the used car business in Congress. Anyway, there are 5 Democratic challengers. Can you believe that?
In Texas, it's early voting season. Have you guys early voted?
I haven't.
I voted today.
I need to too.
AJ, whose district are you in?
Mike McCall.
Are you Lamar Smith? Mike McCall. Are there challengers? Have the Democrats put up anybody?
There are like 10 Democrats on the primary.
Wow,
it's
that's awesome.
Primary.
Are there any good ones? That's awesome.
I don't know. That was a tough call. It's sort of tough for me to imagine any of them actually beating Mike McCall. And it was sort of tough for me to figure out which one's the best. And I don't want to say which one I voted for.
That's cool. There are 5 challengers in my district, and I have to say a lot of them look pretty good. Like, they look pretty good. They look legit. I mean, I'm kind of amazed that there's this much activity and this much action. I mean, this is a district that goes all the way to Fort Worth, I guess. And so there are, there are quite a few. I mean, I don't know, it's like a plus 20 or more Republican district. So I'm glad that Democrats are putting up challengers that seem good.
So Lamar Smith's Texas 21 is one that the Democrats have targeted as a pickup. Like the national organization is saying that they're specifically targeting Lamar Smith's district. I don't think they're targeting Rogers's district as heavily as Lamar Smith's, but it's definitely like on the national radar as a potential pickup in 2018.
Who are the Democrats that are running against Lamar Smith? That's my district.
So Lamar Smith is retiring. I actually have forgotten who's going to be the Republican nominee, but I think Kopser is the front runner on the Democratic side, and he actually I actually think he's got like a real shot.
I think he's going to win, dude. And then let's see, where can I see who his challengers are for Roger Williams?
18 Republicans look to replace Lamar Smith.
Jeez, good luck picking one.
So, guys, should we do sidebars? What should we do?
Let's do sidebars.
There is one Supreme Court issue.
Oh.
Class v. United States came back. If you guys remember, Class was the case where the issue was whether a defendant pleading guilty waives all constitutional appellate rights. So by the fact that he pled guilty without expressly saying, I'm going to appeal based on the constitutionality of your search and seizure, for example, does that mean just by pleading guilty he waives that right to appeal, any other constitutional issues? And by vote of 6-3, they reversed and remanded. Breyer wrote the opinion, and it was joined by Roberts, Ginsburg, Sotomayor, Kagan, and Gorsuch. Alito, Kennedy, and Thomas dissented.
So we had all predicted 9-0.
Yeah, we had predicted 9-0, but it was...
So this is not a case that we had thought was a close call. So I hesitate to give anyone credit for being on the right side of something that's not a particularly close call.
Maybe we should be punished for getting it so wrong. I mean, we were just 6-3. Why didn't we predict the dissenters?
I think if you predict 9-0 and the actual result is 6-3, that's like a very good prediction. I actually think that's like what you should be aiming for. Like, obviously better would be better, but like that's like nothing to be ashamed of.
Should we do the this has been an efficient episode, guys.
Yeah. We can do some sidebars if you want.
Let's do sidebars.
Let's do you have any sidebars where you don't hawk wares?
No. So I have 2 pairs of Warby Parker sunglasses at the moment, and so the Yates is a new pair.
This is really happening.
Yeah. Oh yeah. The Yates is a new pair. It hasn't been sunny in Austin for like 5 weeks, so I haven't had a chance to really wear my sunglasses. But if it were to be sunny sometime in the future, this is the pair that I would buy.
Ruch, do you think we could, like, when you get these, when you hawk these goods, do you think at least you could provide affiliate links so that everything we know in the American heartland gets a little kickback?
I'm hoping that...
I gotta tell you, these sunglasses are really attractive.
Right? Aren't they? They look awesome. So yeah, anyway, I encourage everyone to look at the Yates. Classic navy with classic gray lenses. I don't like the acorn tortoise myself, but I suppose some people could. Anyway, yeah, I think these are going to be good. I'm really quite. I'd like to get them, honestly, and I'm going to have to really think about what the appropriate, what I should do here. It's part of the epigraph collection over there at Warby Parker.
All right, I got a good one.
We should be getting paid for this, Tom. You're right.
Yeah. All right. This was originally posted to Vimeo, and then it got taken down, and now there's a YouTube link. Let me make sure the YouTube link still works. The name of this video is Nirvirna. Smells like teen Sprite.
AJ, your stuff is so weird, dude. Is this like that Kickstarter thing? Did that Kickstarter thing go through, by the way?
Yeah, they raised like over $150,000 for the Devil's Level.
Did you?
Where you control your depression level, horny level, and genius level to achieve Devil's Level 666. That got over $150,000.
This is so very like AJ making us watch a video, and then Ruchit hawking wares.
So check it out. It's Nirvana. It smells like Teen Sprite. So Nirvana Smells Like Teen Spirit in like 1991 was like a big hit single. A lot of you tweens may not be old enough to know about this. And so someone edited Smells Like Teen Spirit to be in a major key instead of a minor key. And you should listen to this because the song is excellent. It's really good in a major key.
I have to listen to this later. Tom, what's your thing?
I'm listening to Smells Like Teen Spirit.
Sprite, you mean?
No, Teen Spirit.
I think they only had to change one of the chords, but they also re-auto-tuned the vocals. So the vocals sound great with the new auto-tune on it.
My sidebar is a study titled Justice, Interrupted: The Effect of Gender, Ideology, and Seniority at the Supreme Court Oral Arguments. And this was a study where they looked at who is interrupting who in oral arguments at the Supreme Court. They found several interesting things. For example, on average, women constituted 22% of the court, yet 52% of the interruptions were directed at them. Overwhelmingly, it was the men doing the interruption. Women interrupted only by 15% of the time, and men interrupted 85% of the time, more than 78% of the 78% of representation on the court. The other interesting thing was, as an advocate before any court, you're not supposed to interrupt the judge or justice when they want to ask a question. In fact, you're supposed to immediately stop speaking. But this study discovered when looking at all of these oral argument transcripts that interruptions by male advocates account for approximately 10% of all interruptions during the study time period. Interruptions by female advocates accounted for, and this is what they say, approximately 0%. In 2015, male advocates interrupted Sotomayor, and that was the most common interruption of the bench, accounting for 8% of all interruptions.
Fascinating.
Radiolab's More Perfect, which is a great podcast, by the way, on legal issues, styled in the sort of general Radiolab way of creating podcasts, did a podcast about this very study, and it's an interesting listen as well if you want to listen to podcasts.
Podcasts.
We know
can't live with them.
Can't
live without them.
I've never found, dude, Tom, strong sidebar. I think of the three of us, Tom takes his sidebars the most seriously.
Tom, tell you what. I will offer you $20 if we can switch sidebars, and I can say that was my sidebar, and you did the Nirvirna Teen Sprite video.
I'm pretty sure Ruchit doesn't know what a sidebar is.
I have to admit, I don't. Is it just something that we talk about? Like that, to me, it's like, something on the side. Like, I don't know. I've never understood what it was from the beginning.
It's like porn, when you see it.
Yeah, and I guess sidebars. I mean, what can I say?
What can you say? I really hope they do something for the Dreamers.
I do too. I think like it's a moral imperative, man. I guess we all have different moral imperatives, but this one I just feel like there's the only reason to not do something, or the only reason to like punish these kids, is cruelty. Like it's not a question of resources. Like I can understand why you if you want to raise taxes or not raise taxes, pay for X versus Y. Like I can see arguments in some of these things. Because it really is a limited resources. It could be reduced to a limited resources question.
Can I put like one postscript on this, and then probably Rich has to go? A while back, we did an episode where we talked a fair bit about immigration, and particularly the economic effects of immigration, and we spent a long time talking about how like immigrants are actually a benefit to the economy, and that they pay more in taxes than they receive in social services, etc. And one of the things that I sort of, as soon as we finished recording, I like immediately regretted is that we didn't actually talk about like just the human value of like immigrants, the humanitarian value of like welcoming people from poorer countries to richer countries, or like just like the meaningful like overall effect on net human happiness in the world that happens from just being the kind of country that like does what it says on the Statue of Liberty. Something that we don't really ever talk about, right? But the like humanitarian value of accepting people from like poorer countries into richer countries and things like that, I think is really, really lost, right? Like even if immigration were net negative for the American economy, I think you would still have a moral imperative to accept people from countries that are not doing as well as our country.
Very well said. Very well said. I think that's like the thing that troubles me is a lot of these, and I'm probably as guilty of it as anybody, but a lot of these things get reduced to almost economic questions as opposed to like, hey, what's the just thing that we can do? And in this situation, the just thing that we can do is beneficial all around. Like it doesn't hurt anybody. It only helps people, you know? And it's just, it's otherwise cruel. And, you know, like some of these stories that we share in the Slack about, you know, the professor in Kansas, for example, you know, who got, you know, picked up by ICE while he was like taking his daughter to school, you know, and who's lived in America for 30 years and has like a paperwork irregularity.
Yeah.
You know, and his daughters will grow up without, you know, if he gets deported, his children will grow up without their father. I mean, and his wife without her husband. And it's one thing to exact that type of pain on him and his family if he was like some sort of hardcore drug lord, you know what I mean? And he had hurt people. But this guy didn't hurt anybody. Just like, you know, none of these kids, you know, hurt anybody. So I don't know, a country that would punish children this way or young people this way, it troubles me from what are we doing here?
Yeah.